Global happenings today. We communicate, we analyze global news. Stay tuned.
Hello, beautiful people. Welcome back to Global Happiness, the YouTube channel. The final verdict is out. Halfway through the ruling, of course, most Nigerians had a fair knowledge of how it will look like. The presidency of Bola Tinubu have been upheld, and of course, Peter Obi, Labour Party's petition has been dismissed. Peter Obi's legal team member, one of the legal team member, Jibril Okutukpe, Senior Advocate of Nigeria, has also reacted to the verdict. Aisha Yusuf has reacted. The Labour Party via their secretary has reacted. Even the presidency have reacted in all of this. We're going to wrap all of this into one. Emotions are flying. Nigerians are talking. The social media is agog over this matter. But before we go into the newspaper, kindly subscribe to our channel by clicking on the red subscribe button. Beside it, you'll see a bell notification icon. Please go ahead, click on it to get notified as soon as we update our channel on YouTube. What Jubril Okutikpe, Senior Advocate of Nigeria, and a renowned attorney, has taken to social media to criticize the tribunal's decision following its decision to dismiss the petition filed by Labour Party presidential candidate Peter Obi, or Peter Gregory Obi, challenging the result of the February 25 presidential elections. Now, in a series of posts published on his account as at now, Okutikpe, one of the lead counsels for Labour Party and Peter Obi before the tribunal, insisted that while the court had rendered judgment in the cases contesting the election's result, it had fallen short of upholding the rule of law. He added Okutikpe bemoaned the difficulties that the majority of the petitioners ran into while attempting to obtain crucial electoral papers from the Independent National Electoral Commission (INEC) in order to strengthen their legal arguments. The well-known attorney concluded his post by saying that regardless of how unfavorable a court decision may be, he has been instructed to follow it as part of his obligations as a lawyer. The well-known lawyer ended his post by noting that regardless of how adverse a court ruling may be, it is his duty as a lawyer to follow it. Let me read word for word. He said, and I quote, "No matter what the judiciary decided based on facts, Nigerians know the truth of what happened on the 25th February 2023 in the presidential election in Nigeria. Truth and facts and evidence in proof are poles apart. While courts rely on evidence of fact, truth does not. Nigeria will do itself well if all the times it upholds the truth in the running of its affairs. Nigerians know the excruciating pains petitioners go through in the hands of INEC and how pink copies of election results are not always given to agents of parties in most cases. Now, judgments have been delivered. Justice is different from judgment. Nigeria shall reap the faults. I think that again, Nigeria shall reap the fruit of what is being dished out by those who trust to do what is right. Those who get judgment know the truth in their heart. Those celebrating know the truth. Truth is constant. By my training, I respect court. I must respect the decision of the court. That is what the rule of law enjoins me to do. But I stand by my convictions with courage for the truth. No baptismal name of legality can make what is not right to become right. Nigerians know the truth." My God, many Nigerians are talking on that. But let's find out really what the presidency is saying. Now, Senior Advocate of Nigeria, Chief Solo Akumas, asked the aggrieved petitioners who are not satisfied with the judgment of the Presidential Election Petition Court (PEPC) Abuja to approach the Supreme Court to further ventilate their dissatisfaction with the declaration of the President Bola Tinubu as president by the Independent National Electoral Commission (INEC). Now, speaking while commenting on the judgment delivered by PEPC dismissing the petition filed by Peter Obi of the Labour Party (LP), Alhaji Atiku Abubakar of the People's Democratic Party (PDP), and the Allied People's Movement, Chief Akuma said the election petition tribunal is the court of first trial. Now, according to the Sun, there is still opportunity to ventilate whatever a dissatisfied party feels was not properly addressed by the tribunal at the Supreme Court. Now, on his part, another senior lawyer, Dr. Yemi Omudele, posited that from the judgment read live, the petitioners had only succeeded in placing something upon nothing that could not stand. In his words, and I quote, "If you listen to the judgment delivered, you will discover that justice is painstakingly analyzed and
I'm very sorry again, sir.
raised and formulated by the parties."
Even if your lordships are going to say, your brethren are going to say their piece later on, sir, at least you all, my lord, you all should be arrested by saying it is either dismissed or is allowed.
It took them several hours before
I was wondering if your lordship would not pronounce that it's been dismissed. So that
what are you saying?
I'm sorry, but I don't want to be confused, sir. I've listened to your lordship's eloquent judgment.
Sorry, please, Leonard Senior. You don't have to interrupt judgment. We are delivering judgment and we are still on. Please leave the judgment where it is.
My lord, I'm very sorry, sir.
If you are confused, when you get the judgment, you read it.
No, my lord, I'm not confused at all.
Okay, then please.
I'm making a suggestion.
You don't have to suggest to us how to deliver judgment.
I'm sorry.
So you seriously think that all five of us wouldn't know that?
Lord,
wouldn't know what you want?
Lord, I apologize.
PEPC presided over by Justice
Apologize.
Samani declared that issues raised by APM in this petition contain pre-election matters that could only be determined by the Federal High Court. Reading the lead judgment, Justice Samani upheld the preliminary objections that all the respondents raised to challenge the competence of the petition. Justice Samani noted that since the petition centered on qualification or otherwise of President Tinubu to contest the presidential election that was held on February 25th, the APM ought to have gone to court within 14 days after Tinubu was nominated by the All Progressive Congress (APC). The tribunal chairman, who explained that since the course of action bordered on pre-election matters, said the APM lacked the local standing to challenge Tinubu's nomination. And furthermore, Justice Samani held that the Supreme Court had elderly decided that a political party does not have the right to challenge a nomination that was made by another political party. And the judge insisted that sections 131 and 237 of the 1999 Constitution, as amended, made provisions for the qualification or disqualification of candidates in that election. And the court noted that the main cross of the APM was on the alleged invalid nomination of Tinubu's running mate Kashim Shettima. In the words of Justice Samani, it is clear that the claim of non-qualification of the third respondent Tinubu centered on the alleged invalid nomination of the fourth respondent Shettima. It's a pre-election matter. A lot of things are being made and said, and in all of this, they said in summary, said tribunal, while dismissing the petition filed by Peter Obi and his party, said they failed to provide credible evidence to prove the allegations that the Independent National Electoral Commission (INEC) did not substantially comply with the Electoral Act in the conduct of the election, and the poll was made by corrupt practices, including overvoting. As of the time of filing this report, the tribunal had already struck out some aspects of the petition filed by Atiku Abubakar and PDP, and Bola Ahmed Tinubu stuff upheld. Of course, the reactions have been trailing. Let's meet in our comment section. Emotions are frayed right now, but all of this, justice has been served. But one thing is certain: the verdict has been served.